we'll get the super chat question, and then we're going to get into Sullivan because it's another amazing one. Go Vols. This is from Christopher Phillips. Any chance Flynn will get a fair shake with this Dem-appointed court composition? FYI, I'm a lawyer and learn so much from this. Thank you. So thank you for the super chat. I can't seem to bring it up. That's Bambugas, and that is okay. So Flynn, first question before we get there. There was the July 30th court order, which set out the question in law to be debated for the parties, which was, were there other appropriate means to attain the relief sought such that mandamus was required, or mandamus? What is up with this second court order that added a second question? Some people were hypothesizing that it was the Republican judges on the bench who were adding this question so that it should be debated. I was thinking maybe this was, I hadn't thought about that angle. I thought maybe it was just the court adding this question so they can find against Flynn on the mandamus and then find against Sullivan on the impartiality, send it to another judge who dismisses the case under the 48A. What's the deal with the second order? How do you think that came to be?
Well, because you have the nature of the panel is where I would start. And the Trump, there's two Trump appointees. One had to recuse himself. We now know that because he's not part of the panel in the second order that was issued, because he was the deputy White House counsel when the Flynn controversy first occurred. So theoretically, he has factual knowledge relevant to the case. So he disqualified himself. It may have been him, by the way. He may have pointed out in his self-disqualification, wouldn't this disqualification apply to some other people too? Not sure. But he stepped down. And so I think you have a panel currently of 8 Democratic appointees and 2 Republicans. So you have an incredibly Democratic leaning court. And I think the interpretation of the first order was correct. So I was surprised by the second order, but it would go to a second issue that I've talked about a lot on this stream, which is that the problem for judges going along with this, even the Obama and the liberal Democratic judges and the Clinton appointees, is this opens up a dangerous can of worms to let judges go AWOL and start appointing their own prosecutors to cases. And this has never happened before. Nothing like this has happened before, anything comparable or analogous. Sidney Powell's done a good job of pointing that out repeatedly in multiple contexts. Not only has every motion dismissed been granted, no judge has ever appointed an amicus against the interest of the government dismissing a case. I know of no such case where that's ever occurred. And the problem is, if they're going to be serious, there's also a core problem with the standing issue. So the question was, how in the world does a judge have standing to bring a petition of writ? It's one thing for a writ to be brought against him and him to respond to it. It is quite another for him to initiate a petition like he did here, where he petitioned the Court of Appeals to hear the case en banc. That is normally only a party can do that. In fact, by rule, only a party can do that. So they decided that somehow he was a party, but then I guess somebody got the intellectual recognition that if he is a party, how is he still in the case? Because under the rules, once you're a party, and it was for him to have standing, he has to recuse.
And so let me stop you there, because there was one question that I think came up, and I think one of the judgments cited answers it. He has no standing in the sense he has no standing for to issue the petition for rehearing because he's not a party. My question would have been, had the decision been to reassign, to remove him from the file and reassign the case, would he then have had standing to petition for rehearing or appeal that decision? And if I recall correctly, one of the decisions that they cited specifically said that a judge who had been reassigned sought, petition for rehearing or sought to appeal that, and it was determined that they have no standing to even appeal the reassignment. Is that right?
Correct. So they have a complete debacle on their hands that if they completely whitewash what Flynn did, they've set a bad precedent for future judges. On the flip side, they don't like Flynn. They don't like Trump. So they don't want to reward Trump and reward Flynn with an immediate writ issuance. So it may be the case that they're going to do a compromised verdict. And I think this is the most common prediction right now, is that they're going to say the writ didn't have to issue because there was the district court could still provide the required relief. That's not quite true in my view, but because the problem here isn't just his refusal to issue the dismissal. If that was the only issue, then they could wait until he heard it. But he assigned a special prosecutor. They can call it amicus, they can call it whatever they want, but that's what that was. And that's the remedy for which there was no relief other than a writ. And my guess is that's what the government will argue on Tuesday. I think the oral arguments on Tuesday. And they'll say, no, we need it writ issued now because the harm is the appointment of the amicus. And so now it's true from Flynn's perspective, that's a partial harm, but the real harm is the failure to dismiss. My guess is, and most lawyers' guess now is, I think your guess was as well recently on the one of the things you did, was is that they're going to cut the baby in half, whack Flynn, and not give Flynn, in terms of not giving Flynn the writ that they want, but really whack Sullivan and give the ultimate relief by saying Sullivan has now made himself a party to the proceeding. We believe that he does have standing, but that very act of getting standing means he had to recuse himself from the file. We're going to remand with an order that he recuse himself, the case be reassigned, and because they figured that could resolve the problem, that the new judge won't have the amicus still appointed, that the new judge will just dismiss, and so the same remedy will happen. It'll be delayed a week or two. And actually, to be frank, I bet Sullivan wouldn't have done this if he'd known that was the solution, because that's a worse outcome for him, because now he's being told he failed to disqualify himself when he was ethically obligated and legally required to do so. That's a worse thing in your judge's file, is a biased judge under the law, that's what its definition is, who failed to disqualify himself when he was supposed to. I'm sure that came as a shock. You saw almost nobody on the left make any commentary about that order. It was almost everybody on there. They were thrilled with the first order, but the second order just didn't quite show up on their news headlines.
So much so that I didn't even hear about the second order. Someone had sent it to me by email. I think the article was in the National Review. No, it was mind blowing because it changed the entire debate. Where the initial prediction I made like 2 or 3 months ago was that the Court of Appeal wasn't going to grant the mandamus, but was going to draft an order in such a way to let Sullivan know that he had overstepped the bounds, do what you have to do under law, but we let you make the decision. That might be what's going to happen now, but it's going to be another judge because Sullivan has gone overboard. Some people were asking, if it gets reassigned to a new judge, does the judge have to take cognizance of the entire file? Does that add months and months of delay?
He can do it now. He can do whatever he wants as quickly as he wants. Now, it's going to be key. There's a lot of liberal judges in D.C., and of course, there's the famous Roger Stone judge in D.C. If she gets it, she'll start it all over again. She'll appoint her own amicus. She'll do the whole shenanigan, the whole show. So it's going to be critical who gets reassigned. I think some of them are going to, some of the Clinton appointees in particular, that's probably your swing vote. The Obama appointees do not have a majority. I think they're 4, maybe 3 or 4. The Clinton ones are more pragmatic. And so they may ultimately say, screw it, we'll just say he doesn't have standing and say that no petition for en banc was improvidently granted, denied, the writ is now enforced. It wouldn't surprise me, put it this way, to see them reconsider how they got down, because here's the problem. They've just said somebody has standing who, by definition of having standing, had to disqualify himself immediately. That's sort of a dumb kind of provision to hold. Just say he doesn't have standing in the first place.
But so that answers one of my questions. Is people think that if this gets to another judge, everything starts over again. They can do exactly what Sullivan did, and it's sort of like it's Sisyphus's rock. My feeling was that no judge would be as stupid, judicially stupid, as Sullivan has been, having seen the way Sullivan is going to presumably get spanked, has gotten spanked, dragged to the mud, whatever. No judge would do that again. They would just
Judge Jackson will gladly top him. This is a judge, remember, who after Roger Stone was commuted, tried to prevent his commutation. She demanded, I want to see the commutation. I want to see if everything was commuted. Oh, yeah. Well, El Trumpo had commuted every little thing. He had some smart criminal defense lawyer go through and make sure every little thing was commuted. But that gives you an idea for how nuts she is. This is a judge who, when she was exposed to juror bias, tried to cover it up rather than deal with it. So she will happily she'll go further than Sullivan did. So that's where I think if they think it through, they have to trust that a new assigned judge doesn't recreate the problem to where they all look bad. The Clinton judges are smart, are pragmatic enough to know what can of worms they're opening. The Obama judges generally don't care. The outcome justifies the means. Doesn't matter how you get there. The law is just like we're talking about with earlier with Miss Obviously. Obviously it is the case that with Obama judges, They don't believe in truth. Truth doesn't matter. Truth is no longer relevant. It's every truth is subjective, which is actually back to both communist and fascist era logic. The Nazis believed that there was Jewish science and German science. There was no objective science. We're back to that world. That's that sort of deconstructionist world that a lot of these people grew up with believing legally, and that they see their power as power. So the Obama judges will want Sullivan upheld. The Clinton judges are probably looking for a compromise that doesn't create a permanent problem in the judicial process.
Okay, amazing. And I'm just going to read Nabody's super chat. Thank you very much, Nabody. Partisan officials have almost destroyed rights in America. No right to privacy. We need a license to travel. We can't go to church or protest unless you are part of the party, etc. What can be done to free us when our judges are against us?
That's the problem. The problem is right now there's no meaningful remedy. So to give another example of that on the it's probably a good transition into the McCloskey case. By the way, there is a right to travel protected under the United States Constitution. That actually is now it's between states, not within a state. But in fact, that's why you have a right to voter registration late. A case Dunn versus State of Tennessee. You can register up to 30 days before an election because it protects the constitutional right to travel. So there is, in fact, a constitutional right to travel. I always remember the great movie Hunt for Red October. And where in one of the scenes in that movie, one of the guys says, "Oh, you mean I can travel from state to state without papers?" And of course, how ironic that is now, because now pretty soon you're going to have your little COVID vaccine chip in your finger, courtesy of Bill Gates, to be able to go to the grocery store. So we'll see how all this unfolds. But yes, it is a significant. When people start now, the real check is public outrage. So when the courts start recognizing that they've outstepped public support to such a degree that the system's credibility is at risk, then they usually step back. My concern is that the new left judges don't have that perspective whatsoever. And they live in the kind of world that Akilah obviously lived in, where she had to keep getting smacked and hit and smacked and hit, and still doesn't even recognize what happened and what the truth is. So good transition to the McCloskey case. More evidence came out of the McCloskey case this past week. The police